Welcome to Trial Lawyer View, a podcast for and about trial lawyers. We tell the stories about trial lawyers who go to battle every day in courtrooms throughout the United States for injury victims. This is about their stories and their practices. Trial Lawyer View is brought to you by Synergy Settlement Services. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues that arise in settlement, like troublesome lien resolution issues, Medicare secondary payer compliance, government benefit preservation techniques, and complex settlement consulting. Without further delay, here's another episode of Trial Lawyer View with Alejandro Blanco.
Welcome to Trial Lawyer Review, the podcast that brings you the inside world of litigation and the fascinating stories behind some of the most significant trial lawyers in the country. Today, I'm honored to have Alejandro Blanco on the show. With over 35 years of experience in civil litigation and more than 130 civil trials under his belt across 15 states, he's established himself as a formidable force in the world of trial law. And I need to read this, so I wanted to give you a little bit of background from his bio. After earning his law degree in Argentina at just 23 years old, he moved to the United States in 1986, passing the bar on his first attempt without going to a U.S. law school, and became the third lawyer with an Argentinian law degree to be licensed in California. He's since obtained record-setting verdicts in traumatic brain injury and spinal cord injury cases throughout the country. His accolades, among many, include being named the 2002 Trial Lawyer College Warrior of the Year in the Western U.S. region, and being one of the 2014 finalists for Trial Lawyer of the Year for Consumer Attorneys of California. He's also the senior founder of Trial Structure and a sought-after speaker on trial skills and securing substantial verdicts. He has served as a consultant for over 27 and 8-figure verdicts in the last 5 years, and is currently involved in catastrophic brain and spinal cord injury cases, as well as helping Marines and their families in the Camp Lejeune litigation. Can't wait to hear his insights and advice for fellow trial lawyers. Alejandro, welcome to Trial Lawyer Review. So delighted that you could join me as a guest today. I appreciate it.
Well, thank you, Jason, for having us. I mean, it's an honor, and I'm humbled. So let's see if I can contribute and what we can talk about that is of help.
Well, I want to start out just a little bit of a background question, because I just found it so interesting about your unique path to becoming a lawyer here in the U.S., passing the California bar without attending college in the U.S. or law school. How did that change or shape your perspective on the legal profession and being a trial lawyer here in the U.S.?
Well, first of all, it was harrowing because, I took the bar back in '87 in July just to figure out what the law was about and how the exams were. South American, or at least Argentinian law school, is 7 years. I happened to do it in 3.5 years, but we studied all sorts of things, one of which is comparative procedure and comparative substantive law. So we had the pleasure of knowing German procedure, French procedure, British procedure, American procedure, but just for federal courts, since you can't really study 50 different civil procedures. You really had to know that stuff. But when you come up here and now you have, a specific bar, everybody kept telling me California bar was the worst, most difficult, nobody passed it. So I just took it in order to pass, or in order to figure it out, warm up. Okay, if I take it 2 or 3 times, I might be able to pass it. And I have to give credit to the folks at Barbary. It's not a plug-in. But back in 86, I didn't have enough money to pay for the books. So I proctored it. And I would listen, I studied, and I saw that my Napoleonic law background did not help with the Saxon law background of California. So when I did take it, to me it was, you always get stress when you take the bar, but in that sense, is I didn't have a problem because I was just taking the bar to see what it looked like. So after 3 grueling days, I went back home and I started the waiting period. Sometime in Thanksgiving time, back in 1987, I got this letter in the box, and I remember just going to open it up, and He goes, okay, it's not it. And I open up and says, we would like to sell you malpractice insurance. I turned to my wife, I'm 24 years old, and I said, they want to sell me insurance. I passed. So I was like, okay, now what? I had no idea. I mean, I knew it in my head. I knew what you were supposed to do. I knew the words. I've never taken a deposition in my life. I never done a trial, mock trial. I mean, I looked at people and, I'd say, what are you guys doing? So the first couple of years were harrowing. I did take a little bit of a time out. I was doing some work with Argentina in terms of international business law, my background. So civil procedure and personal injury in California was not. I remember going sitting down through a deposition and not even knowing what an objection was. So harrowing would be the good way of describing it. Of course, the trusted books, how do you lay a foundation? They would tell me, go take a look at what Magaña says. And I would go, who's Magaña? California legend on evidentiary books and so forth. But it was fun. I had the privilege of having two very, very good experienced trial lawyers, Miller and Medeiros and Dale Grimm. They passed away already, but they were legendary in California, Medeiros and Grimm. They had been part of Hagenbaugh, Murphy, and Medeiros. And then Miller took the best trial lawyer out of a defense firm, opened up a plaintiff firm, and they threw me into the deep side of the pool and said, swim. So that's how I started.
That's an incredible story. I did work for Barbary when I was in law school to get my Barbary course for free. And I would definitely credit Barbary for helping me pass the bar. So, but I can't imagine, that dedication and abilities to go and do what you did and how you did it. Pretty amazing stuff. So you've had now 35 years of trial experience and trying cases in over 15 states. What do you consider to be the top three biggest trial successes that you've had? And then what was your biggest challenges in those cases to overcome to get that verdict?
Well, in terms of having, I even this past weekend in Nashville with John Romano's traumatic brain injury program, I tease the attendees that I had the privilege of not being decerebrated the first year of law school in America. So I wasn't taught to think like a lawyer. But that's an advantage. The disadvantage is while I did go to Berkeley from 79 to 82 as a younger undergraduate before Argentina decided to go to war against England, the problem is I didn't grow up in this generation, in this folks. So I did not know most of the culture codes. And so it was my thinking that if you presented the evidence intellectually and you supported what's duty, breach, causation, damages based upon, what is the legal requirements, that you win. And so the biggest challenge was disowning that notion that if you prove those elements, you win. What I notice is that, and this is this current way of thinking, but from what I saw throughout the years, you would go and prove the case and you would lose. And I personally had, perhaps because of my accent, perhaps because I never really wanted to become Alex White. I always stuck with Alejandro Blanco. That I would have folks in the groups, in the juries, come back and come over and say, don't insult our intelligence. When I had a herniated disc that was asymptomatic before, and I would get, $800, on a rear end trial. Long Beach can be cruel as a venue. But what I realized that the biggest problem is the Defense Research Institute has figured out how to jury nullify the folks, the audiences in the civil arena. So I didn't know how to talk about it. I just saw it happening to me. And Jason, I always tease that I developed PTSD after 45 trials, as a younger lawyer, because, it's like I never knew what was going to happen. Do you know what PTSD stands for, at least for me?
No, not post trial.
Right. It's pre-trial stress disorder.
Yeah.
Because you have your experts, you marshal all your evidence, you have your questions, you know what you're going to do. Then you go to trial, and these folks from the other side, they come up with an interesting way of, like some sort of story that they came up. For example, I had a case in Norwalk, California, rear end at 50 or 60 miles an hour on a stalled car in the freeway. And the defense lawyer got up, good friend of mine, as he's still in practice in California, so I won't mention his name, although I want to. And he said, how do you like to live in a society like this where people sue you for nothing? It only takes $500 to sue you somebody. And so I got my first I proved liability on the rear end, and I got a $0 verdict. So the biggest challenge that I saw was overcoming this, what we now call psychological warfare from the defense, and which is basically every psychological technique to jury nullify our groups, our juries, or to nullify their thinking process so that they are run by emotions. It's they have lately come up with such a vociferous opposition to reptile. And what I've seen, Jason, is that while I understand that reptile ought not to be used to incite the passions of the jury, that's exactly what the defense does. They do a reverse reptile, which is annoying because judges think it's fair for them to do it under due process. Biggest case I've ever had. I've had very good cases, and I'm humbled because as the way I see it is big game, big cases are always a team effort. The trial lawyers that are involved, whether they're leads or co-leads, everyone is part of the team. Paralegals, the associates that that pour out and do the evening or the midnight oil, writing the briefs in order to counter the new motion that the defense gave you at 4:45 p.m. just before you went to bed on a Wednesday afternoon after not sleeping for 5 or 6 days. But the biggest result I had was a lady. I was working in the Palmdale, Lancaster area, and this was a lady had gone into a trailer for a mammogram, and she didn't realize that the door opened outwards, and so she stepped up. She opened outwards and lost balance, and when she fell, both of her knees were hit the iron area, and she had some serious and severe infection. The case obviously was not worth millions. But when we won that case, when the defense finally said, okay, we understand it was a dangerous condition, she didn't appreciate it, and we settled, her dignity was back. She was not the dumbwit that the defense lawyers were putting out to be. And just that recognition, I still look at her in my mind's eye and smile, because it was what the law is good about. It's about bringing dignity and dignified results back to people.
Yeah, very well said. Having been struck by a car while cycling and going through, every phase of a personal injury case myself, it's that is a big deal. There is something about that, feeling like there's some justice to it all. Ultimately, that's what it's about. At least for me, it was very important for me to feel that.
Unfortunately, as I see it, we plaintiff lawyers are the vilified, unsung quote unquote heroes. And I often realize that for the insurance industry and for the corporate industry, we really are, the dregs of society. But for us on this side, when you can bring dignify what I call the appropriate value for the damages done to a human being, it changes things. It really brings good energy back to the group that has been victimized.
So you handle some pretty complex types of cases, TBI, neurologic injuries, catastrophic injury cases. How do you approach building a case and preparing for a trial in these complex types of cases?
Well, what I can tell you is that I have abandoned the building of a case based on damages, that I have abandoned the building of a case based upon duty breach causation, because the other side has figured out how to attack that very well. Over the years, I've noticed that there has been a tendency to say, well, this is us, many of my friends, we had a deserving family, we have a deserving plaintiff. And don't know about you, Jason, but I don't know that all of us are deserving. Does that mean that if you hurt somebody who's not that deserving, who has comorbidities, who for whatever reasons has, diabetes or high blood pressure, that even though they are well-meaning, even though they have made mistakes in their life, that their life is worth less than somebody else? And I have to tell you that in California, as I was growing through the ranks and becoming of age, late 80s, early 90s, the cervical spine injury of a Mexican American individual was worth less than that of a white Anglo-Saxon. And I raged against those limitations, against those goads, because it makes absolutely no sense. And we still have those things. So I don't do things on damages. What I have, and this is part of the trial structure program that we have, is I go directly as to what it is that the defense, the other side, is saying about these particular items that we are litigating about. I've heard both Mark Lanier and Lisa Blue, although it was Lisa that mentioned, is that they talk about there is a dispute. No, there's no dispute. They did something wrong, and now they want to get off the hook. The question is, how is it that they are trying to get off the hook? Is it that they're saying we're not liable at all here? There was no duty? Or if there is a duty, they didn't do anything wrong? Are they saying, well, we might have done something wrong, but somebody else did something else? Or are they saying, and usually they even blame the plaintiff. Last week I was in Chicago working on a hospital case with a fire in the face of a gentleman, and the hospital is literally saying it's not our job to train the doctors on how to deal with oxygen and ignition problems in the OR. It's the doctor's job. Now, can you imagine a hospital saying to the doctor, they're not blaming, So they say, look, fires are unavoidable, even though it's a never event. So they either say that, or they say, well, patient signed a release, if you assume the risk. So they're saying it's not our fault, somebody else's fault. And then finally, they cannot use any of those. They say, well, all of these symptoms are pre-existing. Or whatever we did wrong, whatever our negligence was, did not cause that event. It was not as substantial, it was not a major factor. Or finally, it says, the last resort, is, okay, we did something wrong, we did cause it, but you should have gotten better. And so the first thing that I start looking into a case is, okay, what are they going to say? And how are they going to then close those assertions or those fabrications into a acceptable way in which they themselves have promoted? Have you ever thought about why it is that Allstate has paid this gentleman millions and millions of dollars to say that at Allstate we believe in accident forgiveness? It's because they've been preparing the audience to forgive accidents. And what do you think, Jason, happens when a jury forgives the defense for an accident, when they really are sorry that they hurt, they maimed somebody? So that is the first thing that I do. Everything else seems to, in the structuring, in the organization of the evidence and the trial, even the sequencing, meaning the presentation of the trial evidence, everything works around exposing the fabrication and the flaws of what those defenses are. And you'll enjoy this. I had a case in northern Minnesota. We were looking down in Canada. We were so far up north in Minnesota, where the chief of police on a catastrophic accident said that for him, in his own town, city of Ely, it was all right to jaywalk. And he was telling that to city of Ely residents who were listening to evidence about a severe brain injury on somebody who had come to volunteer to work on the city. So it's fascinating to me how inventive, how creative the Defense Research Institute has come up in order to avoid responsibility. I actually have thought about writing a book, limiting liability as the main culprit of the decline of accountability in America.
So you've mentioned trial structure, and I mentioned it in my opening. Can you explain what it is and how it helps trial lawyers prepare themselves and their clients for trial? And we've had Jamie and Ilya and some others who are affiliated with trial structure, but I thought it'd be good for our audience to hear again, and really directly from the horse's mouth on, how to leverage trial structure to get the best possible results for their clients.
Sure. Well, trial structure is a name that we put to what literally I developed over the years, and candidly out of desperation. The joke or the teasing about developing pre-trial stress disorder is, you're ready, you go and you lose. And you figure, people ask you what happened, and you don't know. What I realized over the years is that if you organize the case, and structuring just means organization. If you put a scaffolding, I've come to the term a molecule. If you organize the evidence that you have in a certain pattern, you will produce results. And it's so apropos that you are just drinking H2O. Because what happens when you have 2 atoms of hydrogen and 1 atom of oxygen? What happens?
Yeah, water.
That's right. Water happens. And if you do that formula, if you do that structuring of the matter, of the evidence in a certain way, can you get, for let's say, gold with 2 atoms of hydrogen and 1 atom of oxygen? The answer is no, you'll get water. So because I'm somewhat of a nerd, and because of, I am, if you will, I need scientific validation for what we do. I mean, Jason, I used to go to all the seminars, 88, 89, 90, and I'd hear the then named big names. I even went and saw Spence, and he would talk with a certain cadence, and we all loved him. But I realized, wait a minute, that is a cult of personality. So what happens if you don't have the personality? Does that mean that you cannot win the trial? I realized that could not be. There was another fellow out of AAJ, or at that time ATLA, Harry Philo. And Harry, would say there was a systems approach. He wanted more of a systems approach. And I realized, okay, if you have a systems, a complete organizational system for the trial, then you can relax and your personality will shine through. You might be a very shy person. You might be a very timid, human being. You might be an imposing male or female. It doesn't matter, because you're speaking truth and you're exposing. The biggest revolutionary finding I have is the wrong act already happened. Somebody's got a herniated disc. Somebody has chronic, soft tissue pain, brain injury, spinal cord injury. That already happened. The way of winning the trial is exposing the way in which the defense, not the defendant, but the defense is trying not to pay for that. And so what I do is I organize in a string of pearls type of structure how to attack the defense unjustifiable excuses. and it works. I heard over the weekend that most people are becoming more and more acquainted, and that they are experimenting with walking away from fear and more into accountability. Well, I've been pushing to hold defendants accountable now for 20 years, since I realized that putting the meaning of the word accountability back into the scope of the word responsibility is what law is all about. And I have no problem having the juries do that and tell people. I'll give you an example of a voir dire that I do. I say, folks, Mr. Lassers, can I pick up on you for a minute?
Sure.
So, sir, the law tells us that, and Judge, I'm not saying anything about the law just now, but the law tells us that we can't have sympathy. You can't have any sympathy, and believe me, there will be some evidence in this particular case that will pull in the strings of your heart. But the law says you can have all the empathy you want, not just any sympathy. So can I get a commitment that no matter how much those strings and how much you want to, from a sympathy point of view, of help, that you will just stick to the law, stick to the facts, and give us your opinion based upon the facts and the law. Can I do that from you, sir?
Maybe.
Okay. Well, and we need to know right now. I mean, wouldn't be a horrible thing for the defense here if at the end of a trial you're looking at all the evidence and you go, let's see, but where the damages are so bad that I need some empathy. I mean, some sympathy here. Come on, let's do something for this person. That would be not fair to them. The law says it's not fair. Can I get a commitment from you that if you have that kind of a problem, you'll raise your hand at the end and say, okay, I need to be excused. Can I get a commitment from you?
Yeah.
Okay, but here's the other thing. The law is good. The law is very good. It allows both sides to have the same rules. So let's say at the end of the case, you look at all of the evidence, you slice it, you dice it, and you go, I thought that Blanco guy was crazy talking about $35 million. But how is the defense going to pay it? See, that would be sympathy for the defense. So can I get the same commitment that you will abide by what the facts are? And you might have your heart pulled and all of that, but if it is $35 million, can I get your commitment that you will make a decision without any sympathy?
Yes.
Okay. And if somebody, and I love what David has done in the past, if somebody says, oh, but how's he going to pay? Can you knock on the door and tell the judge, hey, we need the instruction about sympathy again. Can I get that from you? So sympathy is one of the warfares that is used. I have a case right now in Florida that is being worked because one of the misconducts of the defendant and defense counsel was the fact that, he pointed at his client. And he actually pulled a Jerry Spence on us, had his client sit down in the back row of the courtroom all week long and look down into his shoelaces and look really despondent because he brain damaged a client of ours, and the requests were $14.7 million. So we're up on appeal, and we'll see what the Court of Appeals in Florida says.
As I said in your introduction, been a consultant to over 27 and 8-figure verdicts in the last 5 years, from med-mal to civil rights to brain injury cases. Based on what you were just talking about, what do you attribute those results to, from your involvement in the case? What is it that's being done to get those kinds of results from the jury? Is it dependent on the trial lawyer, or is it dependent on what is being done to, as you've put it, structure the case?
Well, I think that what we do, having done so many of these cases and realizing that, there's really one case. At one time, Jerry asked all of our attendees, it says, have you tried 100 cases, or have you tried the same case 100 times? And we all figured that, you had to become creative. The reality is there's only one case, and it's the betrayal case. The defense has done something that is unforgivable. And we can't let it go. The challenge has been that through this psychological warfare that the defense is using, they flip the meaning of the unforgivable to this is something that we can give them a whole pass. What we do at Trial Structure is we organize the case, we bring clarity to see whether there is in fact things that are unforgivable. And when they are, because we are tribal mammals, because we have in evolutionary sociology certain written mandates that we must abide, what that happens is it becomes very simple for the trial lawyer to relax and require accountability on the defense. We had a case one time, which is, I think Jamie might have mentioned it, North Florida, or what Jamie Holland would call South Georgia.
Yeah.
Where the defense lawyer, after going through about 3/4 of the trial, actually after the verdict came in, went up to plaintiff lawyer and says, how did you figure out my case? So it's like we kept on going back to the war room every night. It says, did he get into the office and just grab our file? Did he read our reporting? How do you figure out our case? And what I can tell is that, and I can give details if you want, I don't want to become boring or specific, is when you figure out what the defense is going to do, at least 98th percentile, it's a very easy to expose their crap. When you don't, and you believe that you are exposing or you're showing the evidence to the jury, then they can hide behind those knee-jerk reactions, what Kahneman calls, the shortcuts, or the quick the quick decision making that juries use, the biases, and they use the biases against us. They call us for greedy. And, of course, we say we're not greedy. We just want $40 million. Well, how's that not greedy? But when you expose it, the fact that they're calling you greedy is because they want to get off the hook of paying that money because they know they owe it. That's a different meaning. That's a different context. And I love the way that other folks, do it in terms of voir dire, and Keith does it in terms of appropriate perspective on cases. We do it in exposing the defense. What happens, Jason, is when the defense does what they are being told to do, then they expose themselves as cheaters in the courtroom, and that realigns the jury, going like, okay, they did something wrong, and now they just want to use legal loopholes to get away.
So is that at the heart of this idea of your approach, making sure that the injury victim gets the compensation that they deserve? Because that I in doing my research for the podcast, that I came across something that you had said about that, and to me that really resonated. Just for one, that's what we do at Synergy, trying to make sure that we enhance and protect the client's net recovery when we're fighting lien holders, for example. But to it, with me, with my own personal injury case, that idea of, making sure that the processes are there to ultimately hold the responsible party accountable for those damages. Because, yeah, 40 million sounds like a lot of dollars, but, I've seen thousands of life care plans that, they're in that ballpark, and a lot more sometimes. And that client is going to be left with not enough money to ever really truly take care of them for the rest of their lives. They're going to be dependent on Medicaid, Medicare, or whatnot. So it just was interesting to me, this idea of making sure the client gets the compensation they deserve through what you were just describing.
Well, yes. One of the things that, and I do tend to try to explain without giving details, but for example, if you have somebody who is, mild traumatic brain injury, which is an epidemic in our country, it's hellish to live in there. The anguish, the confusion, the lack of clarity, And of course, the defense says it's all just psychological. No, it's not. I mean, psychological has a function that is based on our neurological programs and our neurological base. So it's not. But if it's just psychological, they they flip that into it's all in your head, get over it. And the last thing that we in America want is somebody to take advantage of a process. But they are taking advantage by accusing somebody. So I ask one of the segmental approaches, of trial structuring is to let the person that is hurt to saying it's not his or her responsibility to carry the water in the case. They're one of us that just got hurt. And so all they have to do is really explain to us when they testify is when they see, how do they see? When they hear, how do they hear? When they smell, how do they smell? When they taste, how do they taste? And what I noticed, Jason, is if we go to the basics, to the level that we all can understand, if I show you that if you're standing here in front of me, but by the time I get to about 11 o'clock, I see my white shirt, you see it pink, because that's what you see. Now you can begin to understand. You can begin to experience what the other. And by the time I get to about 9:30, 10, I disappear from your visual field. Now I said, okay, what happens over here? You don't see it. And if I go to 2:30 or 3 o'clock, I disappear. Now you understand what is being said by brain damage affecting the visual field. But we need to see what they see. Another thing is smell what they smell. I had an astrophysicist, a molecular physicist. She had a traumatic brain injury, and she kept on telling me that she was trained in Moscow for, if you will, for how to understand formulas through colors and waves, and that she could do in an hour what it would take a supercomputer to do in 6 days by using that, and that she lost that. She couldn't tell that, she couldn't use it. And I remember telling her, I said, it's going to be very difficult for us here in the U.S. to understand what that means. Tell me, what do you smell? And she goes, oh, I smell like rotten fish, oil, all day long. I can't eat anything. And I said, well, before, what did you like to eat? Oh, everything. And now I eat oil because that's what I smell constantly, and I can't. I've lost about 60 pounds. So helping the individual talk about the basic functions of life, see, hear, smell, taste, sense, that has expanded, and showing that in terms of damages, they don't have to carry the water. This case is not about them, it's about what the defense did to leave them in this state.
There was a case that was referenced in your bio, and I wanted to ask you about it out of a lot of the results you had, just because I know our team was actually involved in working with the end client. It's Von Norman versus Newport Channel Inn, which was one of the top 50 verdicts of 2012. Because I actually listened to Mr. Von Norman talk about his case and his injuries, because he did a recording for our team just to have our team better understand what injury victims go through. But I was just curious about your involvement in that particular case and how that case has, whatever that gave you, taking away from it.
Well, first of all and foremost, that is the quintessential example of teamwork. I had the pleasure of working with Nick on that case, and John Carpenter and Steve Glass, who did all the briefing. That was a case that nobody really liked. There were so many red flags. I think it was the lawyer.com, or I forget which publication, that it resembled a communist parade in Russia. I remember putting Jim on the stand, and I asked Jim not to have any coffee, not to have anything in order to enhance his function. I wanted the jury to understand and see how Jim was. He had some pretty severe damage after having fallen from a 12 foot drop because of an illegally low banister on a second floor, I guess, motel. And when he showed up, he was doing his best he could in order to just hang on and testify. Handsome man, tragedy, truly. What I asked him was if we asked you to organize a road trip for a few of us from here to where. And Jason literally, he says, don't ask me to do that. And his hands started to hold onto the side, And I said, well, what happens, Jim, when people ask you to do that? And I got to tell you, we hadn't prepared this. He did not know that I was going to ask him this. He says, have you seen when a plane is hit and they start going down in a spiral? He said, that's what's happening to me right now. Please stop. In addition to that, he knew that he had enjoyed alcohol a little bit too much, and that was the on that evening, of course, and over his life. And he was so candid about it. First questions, in trial from the defense, as the lawyer was walking away from the jury so that Jim would have to follow, was, and the lawyer was walking away, was, how much you drank that night, son? And Jim said, me, sir? I'm an alcoholic. I drank all of it. And that candor, Nick had done such an incredible job, voir dire on alcohol in the beginning, to the point that he had the judge excuse about half of the panel of 30-something people because of, the aberration to alcohol. That when that came through, when that I am an alcoholic came through, it was like sound wave to the jury. And I did not know how much, but at that point I knew, because the defense lawyer stopped, turned around, he realized he had lost the case right there. It was a harrowing case. It was difficult. It was not an easy case. And I got to tell you that it took a lot of trial lawyering, both from Nick and myself. It was one of the most rewarding cases. We offered the defense to settle. We thought the case, the policy covering the entity was $1 million. We offered to settle at lot or below any and all applicable policy limits. So when the verdict came back at 38.6, and then Nick did an amazing job organizing the resolution. I can't talk about those. I'm pretty sure you know about it because you were involved. But that was probably one of the trial miracles that I've seen happen, and justifiably so, because unfortunately the defendants were doing all sorts of not so good things.
Well, I know that your efforts and Nick's and the whole trial team that resulted in that has taken care of him. It's pretty amazing to see how he's done post resolution of that. But that is what trial lawyers do, or speak for those that can't speak for themselves in that context, and make sure that they're compensated appropriately for what's occurred. And I know that was a tremendously life altering. Couple more questions. So there's a lot going on in terms of technology today with AI. I'm curious, looking into the future, what trends do you think are going to emerge in trial practice, and how do you think you'll adapt to those with the deployment of these technologies? Because I could see AI being used in a way that perhaps would make it harder to counteract some of the defense methodologies if they're able to really hone that and make it such that it's really hard for the jury to discern anything?
Well, I think that if anything, AI is going to help the plaintiff bar, and let me tell you why. The defense has been using AI through the brains of 80 or 100 psychologists that they have hired in what's known as traffic analysis. So what AI can do in 15 minutes, the defense used to pay for the larger cases. I mean, when Mark Lanier goes to trial and he's chastised a defense lawyer for over $1 billion on some product case, they've had people come in and take a look at what they've done. I'm sure you're familiar with Richard Jensen, and Richard has been a good friend and a long time, assistant. Although I say that he tries the cases. Martin Peterson, I'm sure you know of, and Martin is really educated me over the last 20-something years on how the other side thinks. And how the other side used to think with honor, but not anymore, since McKenzie changed all of that in the 90s. So I think that what we are going to be able to see is ask questions of the data that we have in the defense, opening statements, closing arguments, even the experts. Just imagine being able to ask AI or machine learning if there's some information regarding consistent, use of specific psychological warfare excuse. And you have, what is the Depo Smith, Trial Smith data, so that you're able to grab everything that John Smith, the trial lawyer for the stars for the defense does, and you see that he has not just a pattern, but that pattern is extremely successful. So I think that the AI is going to benefit us. Literally, I have now a trial that is coming up where we have probably close to 150,000 pages worth of data. And the defense is continuing to amass, and I think they have 160 supplemental disclosures pursuant to federal rules. And 90+% of the stuff is unrelated, comorbidities. But, they're going to ask for the same amount of time to try and talk about everything that is not the trial. And we have a good judge. But I have AI being, worked into in order to separate and to say, okay, what's the likelihood that they're going to use it and how? And then we use it in order to simplify it. I like but what aboutism? That's one of the psychological warfare. Yeah, we hurt the brain, but what about in this? And so we're going to be able to tell the jury in this particular case, so what does the defense have to say about these things? Okay, so there is a brain injury, but what about? And then list the three most important things that we can rank according to diagnosis. Now, I don't know about you, but I don't like to read 150,000 pages. Even the medical records that we summarize were, something like 17,000 pages, and we summarized them into 600+ pages. I had a hard time digesting all of that and remembering it. But if you can have AI do that, that's good. The disadvantage of AI, I think, is they can do the same thing against us. I've seen, for example, utilizing Nick's example. And by the way, Nick is one of the best trial lawyers I've seen. I had an honor to work with him for a number of years as trial partners. But they start saying, okay, now he's going to come on here and do A, B, and C because they studied him. And so either you do it and you perform better, or you don't. So I think that AI is going to help, as long as the insurance companies are willing to pay it, some of these lower tiered trial lawyers for the defense to organize themselves better against the successful strategies. I spent some time with Joe Freed over the weekend, and he's developed an amazing, speed trial, and just giving the jury exactly what they want, knowing So AI can help us also. We do a survey. What is it that the specific group of the specific county wants to know about this specific case? So we can tailor our cases to that. And with the diminishing value or diminishing because of competition of AI, I think that that's going to, like any tool, Jason, I think that if used properly with a system like trial structure or any other trial school that you follow, that you can minimize the cost of taking a case to trial, which is very expensive, as you know.
So, final question, and we appreciate all the time you give me today. Open-ended, because it's trial lawyer view. What is your view as a trial lawyer?
Well, I wanted to be a writer. My background was more into philosophy. That's what I studied at Berkeley. I was more into when I came to Berkeley at age 17, already with a bachelor's degree from Argentina, I wanted to study the origin of meaning, because I figure, if I could discern, and by that time, Jason, my dad thought I needed to be kind of studious, so I was already a professor of French literature. The existentialist can mess a young man's brain. I was a professor of British English, and I figured, I spoke about 5 languages. Not very difficult to speak Portuguese when you speak Spanish, and then a little bit of Italian in the mix. But I figured if we could find out how it was that folks would call it a tree, and in France, or it would be an arbre. If we could then, pointing at the same entity, we could devise the meaning, then I figure, we would be ahead of, the game in answering some of the questions. Now, of course, we had no idea about black holes. We had no idea about the rest of the things that we've discovered over this, I guess, close to, 40 something years. As a trial lawyer, there's a lot of work to do. And I imagine that as I was growing up through the ranks, the older trial lawyers thought that the profession was going to end. Jerry is in his 90s now. I met him when he was in his 70s, sorry, about 23 years ago. And he was talking about the end of the trial lawyers. However, I see that every generation produces a number of men and women, more women, thank God, these days, that continue to pick up the torch, that continue to say, not under my watch, not while I have the ability to learn and break. And mind you, we're very successful. I am very humbled about the successes of my career. I think that my perspective, my view is, as long as I can give away the gift that was given me, and mind you, I did not start getting good results until my mid to late 40s. And I've been a lawyer since I was 23. So it was a long, I guess, a desert journey for me. It wasn't 40 years like the Israelites, but it was a long place. And many times during that time, I said, "What am I doing? I'm not a trial lawyer. I don't know how to do this. I should quit." And I did a couple of times. But as long as somebody wants to stay in the process, I think I'll be willing to teach through trial structure those folks that really pick it up. I used to have dreams of 10,000 lawyers. Now I just want 300. I think that with 300, and I'm certainly not Leonidas, nor do I want to be, but as long as we have 300 lawyers trying cases every year, every Monday, hopefully we'll get to 10,000 after Xerxes is defeated. But my perspective is, there's new waves. I'm 61 years old. I'd like to hang the shingles. Actually, I retired 6 years ago, but nobody got the text. And right now, I think that my biggest project is to help men and women both Marine and their families out of Camp Lejeune, because that is not just a once in a lifetime opportunity, but I believe that it is such a massive tort, not a mass tort, but it's such a massive tort that the best generation that America ever produced, those folks that are in their late 60s to mid 80s, need to be honored. We don't need another wall in DC. We need their lives to be honored right now. And I think that as the news of those trials begin to expand, I think that we're going to have more, boys and girls in early 30s in the trial lawyering pick up the torch and move on. So teach as much as I can, enjoy the rest of my life, because I've made a lot of sacrifices. My family has made tremendous sacrifices, and I'm so thankful to my wife, who's also a lawyer, who put it together for us. I don't know how else to say it. I wish we could all stay human beings and become better human beings while we also wear the hat of being a trial lawyer.
Well said. Great point to end on. So if one of our listeners wants to get in touch with you or wants to learn more about trial structure, what's the best way to do that?
Web is there, trialstructure.com. You can certainly email me either at alejandro@trialstructure.com or brad@trialstructure.com. He's our executive officer, director, that is. A Blanco at theblancolawfirm.com is my direct. I'm plenty busy, so if I take a little bit to get back to you, my apologies. You can even text me directly. My cell is 661-810-2027. I learned over the weekend that Mark Lanier, even though he's busy, he will always answer the phone call. So I figure if Mark can do it, we can do it.
Well, thank you again for taking the time to be with me today. I appreciate it, and we'll see everybody on the next episode.
Thank you for tuning in to Trial Lawyer View. We hope you enjoyed today's discussion and encourage you to tune in to our next episode for more helpful insights about your practice. This podcast is brought to you by Synergy Settlement Services. Visit synergysettlements.com to learn more about how we allow trial lawyers to focus on what they do best.